I call Eugenie Sage.
Tēnā koe, Mr Chair, thank you. Pleased to take a call on the Hurunui Kaikōura Earthquakes Recovery Bill. And we'll just say before starting that the Green Party is thinking of many people in Indonesia's Aceh province. Certainly there hasn't been the destructive tsunami that there was in 2004, but hundreds of people there have lost loved ones and a lot of people have suffered serious injuries. So we are really thinking of the people in Indonesia suffering as a result of that massive earthquake. I think too that the people of Kaikōura, South Marlborough and North Canterbury, as they are struggling with their damaged homes, how to rebuild their businesses without State Highway 1 and the visitor traffic that provides, should can we assure them that here in Parliament we have been dealing with this legislation, trying to get it through as expeditiously as possible, and the Select Committee and officials have worked very hard on that, and would certainly like to recognise the work of officials in the Department of Prime Minister and Cabinet and the officials that they have consulted with, Ministry for the Environment and others, Select Committee, staff of the Local Government and Environment Select Committee, Parliamentary Council and everyone who has put a lot of energy and very careful thought into this bill, and not least to acknowledge the Minister, his preparedness to engage with Select Committee as a result of our consideration of submissions and thoughts around the bill. And I think, again, Mr Chair, this bill, even though it only went to Select Committee for less than a week and submissions were only open for a working day or so, highlighted once again the value of the Select Committee process, because the bill has come back to the House through the SOP process with a number of changes as a result of submissions and as a result of the committee's consideration. As Mr Parker noted, and as the Regulations Review Committee discussed in its report, some have certainly suggested that it would be desirable to have legislation around recovery from a national emergency prepared as much as possible in advance. And certainly, superficially, that is attractive because it means that the issues are considered in a reflective and a measured way. But I think the shortcoming is that potentially such legislation, because it's generic, would have to provide very broad powers, potentially larger than are needed. So even though it means that people are working under pressure, I think with this bill, bespoke legislation is better because there is focused attention on the powers that it should provide and the situation that it should respond to. And so certainly acknowledge the Green Party's appreciation of the work done by the Regulations Review Committee in finalising its report into Parliament's legislative response to future national emergencies. That was a very good series of recommendations that I think assisted the Local Government and Environment Select Committee, particularly because it built on the work done by the Law Commission. The Green Party's considered this bill very carefully. Like everyone, I think, in the Parliament, we're reluctant to support legislation which allows the Executive, through orders in Council, to modify, suspend and override primary legislation with no opportunity for parliamentary debate, public submissions and scrutiny and consideration by Select Committee. And as submitters noted, particularly constitutional lawyers and also Dr Anne Brower, that breaching constitutional norms, as Dr Anne Brower said, is a bit like eating fish and chips. If you're going to do it, it had better be worth it. And I think certainly the Kaikōura Hurunui earthquake sequence, the huge damage that they have done to the land there, the access that they've cut off to Kaikōura, means that emergency powers are required. And so we acknowledge that the bill, as introduced by the Minister, did improve on the Canterbury emergency legislation in response to the earthquakes there, with additional safeguards, the fact that the orders in Council that are made by the relevant Minister must be necessary or desirable in terms of the proposed purpose, and they can't be broader than required, and that this bill has a list of acts about which orders in Council can be made, rather than being a much more blank cheque, as Mr Chair.
Eugenie Sage.
Thank you, Mr Chair, as in the Canterbury legislation. So those Henry VIII provisions, as they have been or are called, were rightly criticised in the Canterbury earthquake recovery legislation because of the very considerable powers that they gave to the executive to suspend and modify acts of Parliament. And there they were able to override all but a handful of acts in relation to constitutional matters and custody and detention. So, Mr Chair, it is positive that we have Schedule 2 in this bill and the list of some, I think, more than 40 acts which the bill applies to. Those themselves are very broad acts. They include things like the Resource Management Act, the Conservation Act, the Railways Act, the Maritime Transport Act, the Land Transport Act and others. In Select Committee, we have inserted some additional safeguards in recognition of the concerns that were raised by submitters and also our own concerns. Like the Labour Party, the Green Party would have liked to have seen a protection of the ability to take judicial review because that provides, the courts provide through their scrutiny of ministers' exercise of the Order in Council power an additional check and balance. But we are pleased that the changes have been made to Clause 8(4) and Clause 16, I think it's 4, where there's a provision that nothing in the Act except as provided in the clause prevents a court from determining whether an order is authorised by this Act. And what that effectively means that if an order is ultra vires, if it goes outside the purpose and the scope of that purpose, then there is the ability to invoke legal action and ask the courts to examine that. So that is certainly making that much clearer than the provision in the bill as introduced. Also pleased in terms of Clause 16, where the Minister wants to use an Order in Council in relation to acts that aren't in Schedule 2, then the Minister must put the proposal for the draft order to the leaders of the parties represented in Parliament with the reasons he or she wants to make that order, and he has to be or she has to be satisfied that there is near unanimity from the parties that the order should proceed. So while it's not coming to the Parliament before the order is made, there is quite a deal of political influence in that provision. And of course, in this clause, if there are orders in Council made which bring in and affect additional acts to those listed in Schedule 2, those orders in Council have to be affirmed subsequently by the Parliament. In the Green Party, we would have liked to have seen that affirmative resolution procedure apply to all orders in Council as an additional check on the Minister's powers and a safeguard against abuse, but we will be supporting this bill and we're not using the fact that that's missing from the bill as a reason to oppose it, and that's partly because of the additional safeguards around orders in Council, the composition of the review panel, which has a number of people with specific expertise on that, the fact that the Minister must have regard to the advice and consider the advice that the review panel provides, the fact that there is now a process for seeking some public comment, and my colleague Jan Logie may talk further about that, so that these additional safeguards have, I think, put better checks on the Minister's powers. And the other major improvement that Select Committee made was in relation to allowing additional geographic areas which hadn't been affected by the Hurunui Kaikōura earthquake sequence, additional local authorities that hadn't been affected to have orders in Council imposed there, and Clause 16 has been amended so that provision about the Minister specifying one or more local authorities where orders could apply has been removed, so it's very much restricted to those local authority areas that have been affected by the Hurunui Kaikōura quake. But nevertheless, as Mr Parker has said, the ambit of this bill does apply to a large geographic area from the Waitaki River right through up into the Wairarapa, even though...
Dennis O'Rourke.